Hello, everyone, and welcome to Iranian Center for International Criminal Law webinar on the role of special procedures in protection of human rights affected by unilateral coercive measures. My name is Mohammad Ali Abdullahi, and I'm speaking to you in an autumn afternoon from Tehran. I have the honor to moderate this webinar today. This month marks the 6th anniversary of the appointment of the Special Rapporteur on the negative impacts of unilateral coercive measures, and in particular, economic sanctions on the enjoyment of human rights by the UN Human Rights Council. In October 2014, the Council decided to appoint a Special Rapporteur with a mandate to study developments and challenges of negative impacts of unilateral coercive measures, and to make recommendations on ways to prevent, minimize, and redress the adverse impacts of such measures on human rights of the population of targeted territories. Under the UN Charter system, it is the Security Council as the only organ able to take any enforceable measures, including sanctions, in response to threats against international peace and security. Therefore, there is no ground for imposition of unilateral sanctions by states, specifically when it negatively affects the human rights of the peoples of the sanctioned territory. The fact that unilateral sanctions and coercive measures are in manifest contradiction to international law has been recognized and condemned by various UN organs, including General Assembly and Human Rights Councils in a number of occasions. Unilateral sanctions with extraterritorial application often amounts to violations of a wide range of human rights, from right to health and life to right to education and work. It is worth mentioning that even this webinar has been affected by unilateral sanctions, since anyone from Iran should use virtual private networks or VPN to join Zoom meetings due to United States unilateral sanctions. Anyway, the human costs of unilateral sanctions and their negative effects on the civilian population of targeted states are really alarming. The speed of development of unilateral sanctions regimes and the existence of minds addicted to sanctions encouraged the United Nations to step in and to observe and protect the human rights of those who are affected by sanctions. For this purpose, the UN Human Rights Council decided to appoint a special rapporteur to document negative impacts associated with unilateral coercive measures with a view to accountability. As Professor Shabas discussed in our previous webinar, unilateral sanctions may amount to crimes against humanity when they cause great suffering and serious injury to the health of civilian population of the targeted territories. Today, we would like to hear more about the role of a special rapporteur in protecting human rights and promoting accountability for violators of human rights resulting from sanctions. I'm pleased to introduce today's speaker, Professor Alena Douhan. Professor Duhan is an international law professor at Belarusian State University. We know that Belarus recently hit the headlines due to incidents after its presidential election, and we hope a peaceful solution for the current crisis. At the beginning of this year, Professor Duhan was appointed by the Human Rights Council as the Special Rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights. She took her office in March, and since then, she has been engaged with various actors, including states affected by unilateral coercive measures and sanctions. For instance, some month ago, she approached two relevant states with a questionnaire on various aspects of unilateral sanctions in the course of pandemic, and several states, including Iran, welcomed her initiative and responded accordingly. Also, in implementing her mandate, Professor Duhan is in very good connection with civil society, and today's webinar would be seen as part of her approach in this regard. Before I give the floor to Professor Duhan, I would like to add that we will look forward to hearing from you during the question and answer section. So please feel free to share with us your comments and questions. And at the end, Professor Duhan is going to share his comments on your questions. So without any further ado, I would like to begin the main part of this webinar by giving the floor to our guest speaker, Professor Alena Douhan. Professor Duhan, once again, I deeply appreciate your presence and acceptance of our invitation. You will have the floor for the next 15 minutes. Thank you.
Thank you very much. Well, it's a pleasure for me to speak at the webinar on the problems of application of unilateral coercive measures and their humanitarian effect. It's a huge pleasure for me that the problem of unilateral sanctions started to be discussed now. From the other side, that's a huge problem, as far as it's usually discussed either by sanctioning states only or sanction states only. And today I will try to demonstrate how much the application of unilateral sanctions are affecting human rights in various situations. And secondly, what can be done by the special procedures to improve the situation as such. Special procedures have not a long history in general within the Human Rights Council. The very first one was established in 1985. That was a special rapporteur on the prohibition of torture. And in 1986, a new one on the freedom of religion was established. The mandate of the special rapporteur on the negative humanitarian impact of unilateral coercive measures on the enjoyment of human rights is one of the very recent ones. As you have correctly noted, it has been established in 2014. Only 2 special procedures have been established afterwards. So now it's basically the 6th year of functioning of the procedure. Special procedures have very specific status within the human rights system of the United Nations organizations. None of special rapporteurs can be viewed as the judicial body. None of them is the employee of either of state or the United Nations. So the special rapporteur is supposed to be a totally independent expert, not being paid by any side which can be involved into the consideration of the situation. And as an independent expert, the special rapporteur has duties to consider the situation as such and take a number of various steps to improve the situation. I won't go in depth into the functions of the special procedures now. I will finish with it when describing what measures can be taken by the special procedures in order to assist the improvement of the humanitarian situation and improvement of humanitarian consequences of unilateral sanctions. Now I will try to make an overview what are the new developments of the unilateral sanctions today, because I have to admit, for example, that even 5 years ago, nearly 6 years ago, when the mandate of the special rapporteur has been established, unilateral sanctions looked absolutely different in comparison with how they are looking now. Today, we can state that basically unilateral sanctions have changed and are still changing a lot. We can state that they are expanding as concerned the scope, times, means, mechanisms, subjects, and objects, as well as grounds for their introduction. None of what I have said says nothing about their legality and illegality. That's just the statement what's happening right now. And I will try to provide now the general international law overview in which we are supposed to assess any type of unilateral sanctions. In accordance with the UN Charter, the UN Security Council is the only body entitled to apply any enforcement measures, both military or non-military, in the situations of the breach of peace, threat to peace, or an act of aggression. At the same time, despite the fact that the authority of the UN Security Council has never been doubted at the international law to impose such enforcement measures, at the beginning of 2000, it started to be clear that the humanitarian impact of absolutely legal UN Security Council enforcement measures is still enormous. But the very effect exists as concerned the purposes they were seeking when they have been introduced. As a result, the UN Security Council chose not to apply comprehensive sanctions anymore, and limited itself to the really selective targeted sanctions and in sometimes like a broad, more expanded measures. But it stopped to impose comprehensive economic sanctions as well as comprehensive sanctions as well. When we speak about individual states, there is absolutely nothing in the UN Charter which provides individual states with the possibility to impose unilateral sanctions. In general, the states are only free in accordance with international law to act if the activity, unilateral activity, doesn't violate any rules of international law. Naturally, every state is free to select whether they want to cooperate with another state or do not. But if an international treaty has been concluded, it shall be observed. In the same way, if the state, for example, can denounce the international treaty, it shall be done in accordance with the standards set in this exactly international treaty. Individual states can also take some steps in the course of countermeasures in response to the violation of international law by another state. In some very rare and very specific states, countermeasures can be taken in response to violation of so-called collective obligations. And the International Court of Justice has stated in one of its cases that while collective obligations, so these erga omnes obligations, shall be of the very validity for the international community as a whole. So the grounds for application of countermeasures in response to violation of collective obligations can only happen if a state is committing, for example, an act of aggression or genocide or mass gross violation of human rights shocking the conscience of mankind. That means when we have lots of people being dead, tortured, and so on, and we're not speaking about one or two, we shall speak about mass gross violation. Violation of specific human rights doesn't result in this qualification of the mass gross violation of human rights shocking the conscience of mankind. But at this point, I would like also to draw your attention to the point that usually when we have either an act of aggression or genocide or mass gross violation of human rights, this case starts to be considered by the UN Security Council usually. So that's not only the individual states who are concerned about doing it. We shall also take into account the existence as the peremptory norms of public international law, the fundamental principles of international law, such as the principle of sovereign equality of states. Non-state can judge the behavior of another state, the principle of non-intervention to domestic affairs of states, as well as the principle of peaceful settlement of international disputes. And indeed, today, that's the only legal framework we have when we speak about the unilateral activity of states. Let's look what is happening right now. First of all, we can hardly speak about application of comprehensive sanctions today, but we started to speak about the very broad financial as well as sectoral sanctions applied today to a number of states. And for example, when we speak about Russian Federation, sectoral sanctions are applied to mining, oil, gold, and other areas of financing. When we speak about Iran, we are speaking about financial and oil sector. When we speak about the Venezuela, we speak again about the financial, oil, and gold sector. What's happening as a result? People being involved in this area lose their jobs. They have no money to buy their food. We have an increasing rate of unemployment, decreasing rate of social guarantees. These people have no money to buy some food, and the country themselves lose any possibility to buy food or medicine or any other things. I believe in this case, sanctions imposed last Friday by the United States on Iran, I believe it regards like 18 Iranian banks which have not been listed before, are qualified by the European Union as undermining the very ability of Iran for any humanitarian imports. And from the assessment of the, not of Iran, not of Belarus, but from the European Union, the main import stuff were medicine and grains. So it basically means that there will be problems of buying food and buying medicine for people, especially in the time of economic breakdown, economic crisis in the cause of COVID first, and secondly, to treat the people who already have got sick. The second tendency we face now is the expanding application of targeted sanctions. That means that every state is introducing new lists of people or companies which are targeted by these sanctions. A clear example of this case is initially Magnitsky Act aimed upon several individuals within the Russian Federation. If I'm not mistaken, the list includes today about 50 individuals. And the so-called Global Magnitsky Act, which is targeting individuals and companies all around the world, including China, Latvia, many other, for being involved, for violating human rights in some way, not specifying in which way and not specifying what evidences can be found, and secondly, for corruption as well. But the problem is that neither of these types of activities can be qualified as crimes falling under universal jurisdiction. Moreover, no attempt has ever been made to bring these people to criminal responsibility if they committed these crimes indeed, and if there was any case which allowed for qualification of whatever they have done as being qualified as an international crime. So as a result, when we take the case of the United States, upon the decision of a single person, the President of the United States, by the act of executive power, by executive bodies, people are announced for all around the world to be guilty in committing certain crimes and therefore to be punished by imposing financial limitation, by imposing the limitation of their freedom of movement. So they are prohibited to enter the territory of the United States as well as alias of the United States. Moreover, the problem exists that none of these people has any possibility to protect their rights in any judicial institution. Situation is somehow different when we speak, for example, about targeted sanctions of the European Union. The European Court of Justice, in accordance with Article 275, of the Treaty on Function of the European Union, can consider the case, so-called sanctions cases. And despite the fact that it was pretty inactive at the very beginning, it has considered about 300 cases within the last 3 years. And that's pretty obvious that in the majority of these cases, the court came to the conclusion that the European Union bodies have violated human rights of those who have been targeted by the European Union acts. So quite a lot of acts have been recognized to be invalid. And that's a clear designation of the fact that the targeted unilateral sanctions are affecting human rights. And it's necessary to take into account any humanitarian consideration on the case. So if we speak about the targeted sanctions in this case, we mostly speak about the violation of the right to fair trial of the individuals who have been targeted by targeted sanctions, as well as individuals being involved into the activity of enterprises which have been targeted. Moreover, the very scope of people as well as the types of people who are targeted by targeted sanctions is expanding today a lot. A clear example of this is imposition of targeted sanctions over the judges and officials of the International Court of Criminal Court for the decision of the court on existence of jurisdiction over the crimes against humanity and war crimes committed by the US and US-controlled personnel during the operation in Afghanistan. Naturally, United States didn't recognize jurisdiction of the International Criminal Court. At the same time, war crimes and crimes against humanity are making a ground for execution of universal jurisdiction. So the International Criminal Court decided that they need to consider the cases. As far as the United States government didn't start any proceeding, or if it started, the verdict was very, very soft. The same concerns attempts of the International Criminal Court to consider the commission of the crimes against humanity and war crimes at the occupied Palestinian territory by Israeli and Israel-controlled forces. And as a result, the United States took a decision to target the judges and the officials of the International Criminal Court, as well as people who are assisting the court. It's pretty interesting, however, that a number of the US lawyers has made a petition to the Supreme Court of the United States, and they have written over there that they are scared after this decision to teach international criminal law because or consult anyone relating to the International Criminal Court, because they, via the university professors in the United States, are scared to fall under the secondary sanctions in accordance with this executive order. And naturally, that's not only the violation of rights of these international servants, that's not only undermining the independence and immunities of these people, that also undermine the rights of the people whose rights were violated by the crimes against humanity and war crimes for any remedy to fair trial, the right to be protected by the rule of law. Well, again, when we speak about the secondary sanctions, that's a new development of unilateral sanctions in the international law. Here we start to speak not only about the sanctions to someone violating the initial norm or committing whatever crime. We are starting to speak about sanctions which intend to punish people who cooperate with targeted entities or targeted countries. And these developments started to be absolutely enormous. The clear example of this is Caesar Act, which turned into law in December 2019 and is aimed against any foreign cooperation with Syria. So theoretically and practically, the United States intend to punish every entrepreneur to be involved into cooperation with Syria, including in the reconstruction of anything within Syria. Quite a lot of buildings within Syria are destroyed after the military conflict and the activity of ISIS. And it's indeed, people have no place where to live. People have no food to eat. People have no hospitals to make tests against coronavirus. In accordance with today's statistics, Syria is only able to do about 100 tests per day, and that's absolutely nothing when we speak about the population of Syria. So as a result, every foreign person who will decide to be involved into the reconstruction program in Syria is claimed to be a criminal all around the world, regardless any grounds of jurisdiction, just in order to put maximum pressure on Syria. And as you realize, it has absolutely nothing to do with application of any types of countermeasure. Moreover, the same type of secondary sanctions can be applied to let's say, people cooperating with targeted individuals or companies all around the world in accordance with a number of other aspects. When we speak about the US secondary sanctions, they are usually very, very severe. If it goes within the civil suit, the punishment may be up to $289,000. And when it comes to the criminal case, it can be up to $5 million. When it comes, for example, to the imprisonment, in the case of the criminal case, the imprisonment in accordance with different executive orders may vary from 5 years up to 20 years as a sort of secondary sanctions with no other violations. In practice, it results in the already cited rejection of the university professors to speak about international criminal law with their students. It results, for example, in the cases when lots of captains of ships reject to deliver anything to Cuba or to Venezuela. It results in this situation when, for example, Iran forwarded several tankers with gasoline to Venezuela because Venezuela is facing an enormous economic and fuel crisis today. So people have no electricity, people can't get to schools, to hospitals, or wherever. And all captains have been placed under secondary sanctions because fulfilling their job and violating absolutely no rule of international law. The approach of the European Union towards the secondary sanctions is much softer in comparison with the United States, but still they apply secondary sanctions in some way, but they try not to do it, let's say, extraterritorially. Well, if we speak about the not individuals, but broader application of secondary sanctions, the ones which we observe today relate, for example, again, to the sanctioning people who are assisting the officials of the International Criminal Court, sanctioning people who are involved into building of the Nord Stream 2, and so on. So another development which I would like to mention is the expansion of the application of cyber sanctions. Today, we all live in the world of cyber technologies, and as a result, use of cyber means becomes a means of application of sanctions on the means of putting pressure over different states. One example has already been mentioned as concerns impossibility for Iranian citizens, as well as citizens, for example, of Crimea, or citizens of North Korea, or Cuba, or some other countries, to use educational platforms, including Zoom, which are controlled by Google. The same situation exists even as concerns applications which are developed by national states. And here I speak about this AC-19, which has been developed by Iran, but which can't be used by Iranians, despite the fact that it's being developed by Iran because of the Google censorship. The same situation relates professional databases. There are huge problems for even for doctors from the targeted countries to get access, for example, to the PubMed, the educational platform and communication platform for doctors, where the means of treatment and diagnosis of COVID-19 has been discussed, and which was intended to help a lot in their work during the pandemic. The same applies to the situation when we speak about the students or people at school, which are intending to have to work distantly and have to study distantly because of the limitations and quarantine imposed by the pandemic. Another problem concerns situations of online payments. Due to the very fact that quite a lot of platforms for payments, as well as payments in the US dollars, are controlled by the United States, quite often payments can't be done. And moreover, the time for consideration whether the payments may be done becomes really enormous. It's not a day or two as we used to have, that may last up to 45 days. And moreover, the duration of the time doesn't mean that in reality the payment will be finally done. Again, if we bring together the development of cyber sanctions as well as secondary sanctions, one of the other problems we face today by the humanitarian non-governmental organizations, which are involved actively into the delivery of humanitarian aid. In accordance to information received from these organizations, quite often it takes them lots of time to make any payments to buy food or to buy medicine or other essential goods. Secondary, it becomes both for targeted countries and humanitarian organizations to get permission or to get license to buy these humanitarian goods. And as a result, prices are rising, humanitarian aid is not bought, and it can't be delivered as well. Moreover, the humanitarian organizations working in the field are very scared to be subjected to secondary sanctions as well, for doing their humanitarian job. And here I would like to bring attention to the fact that the very fact of sanctioning won't depend on the nationality of people working in the field for this NGO, trying to provide humanitarian aid. If we look at the situation which develops with COVID-19, it made humanitarian effect of unilateral sanctions much clearer than before. I have mentioned several facts which are very related to the development of COVID-19. But inter alia, I need to mention, for example, that due to the economic crisis from one side and due to the limitation of the paying possibility of targeted countries, as well as, for example, freezing assets of central banks of countries in the foreign states, these countries can't buy humanitarian goods, and moreover, basically can't resist the pandemic as good as they were supposed to do. A clear example over here is the impossibility to buy not only medicine, but also to buy any medical equipment, including the protective kits, so such simple ones like the masks or any other stuff like that. Payments can't be made, goods can't be delivered. If someone wants to get a license to deliver humanitarian goods, it's very expensive, the process is not transparent, and it lasts a lot. And as we realize, when it comes to the development of the pandemic, or when it comes to the development of certain other aspects in this sphere, it's necessary to react very fast. Because when lots of people got sick, we start to speak not about the violation of some secondary rights. We start to speak about violation of the right to life. People are dying because of everything what's happening over there. Secondly, some of targeted countries have already started to suffer because of this shortage of food. So people have nothing to eat. In accordance to the recent UN statistics, people are able to get approximately 1.5 meals per day in Venezuela. So they have only half of the ration for a normal functioning of the person. When we speak about something what goes not in Caracas, but beyond Caracas, only 20% of people are able to go to school, because they have nothing to eat, they have no possibility to get there, they have no electricity all around, and they have no fuel all around. And moreover, there are health limitations as well. Moreover, it's pretty impossible to buy medical equipment which is necessary to treat not only COVID, but all other diseases. Because companies, for example, which are controlled in the first hand by the United States, do not want to deal with targeted countries or targeted companies. There were cases, for example, in Cuba, which used to buy certain type of medical stuff from the same company for dozens of years, that they stopped to be able to do it because the company was bought by the United States. This situation, however, is much worse, but because both companies, any transportation companies as well as banks, are all the time scared of secondary sanctions. As a result, they prevent the processes to be done, they prevent the purchases, and all these affects human rights badly. So if we look at the negative consequences of human rights in the course of pandemic, here we can speak about the violation of the right to access to information, right to education, right to health, right to food, and even the right to life. And naturally, the most vulnerable categories of population, like children, women, people with low income, people unemployed, people who are homeless, people who, let's say, suffer from the severe diseases, as well as doctors, are affected the most in this situation. Well, what can be done by the special procedures? Theoretically, the special procedures can do lots of types of activity. In reality, the very first purpose of establishment of special procedures was to bring a problem to the attention of the world community. to speak to civil society, to speak to states, to speak to non-governmental and governmental organizations. One of the problems is that the people, we used to hear the word sanctions so much. We hear it every day. We hear about new sanctions every day. And as a result, we are not surprised with it anymore. We do not start to consider what the word unilateral sanctions means. That's surprising, but until today, there is no definition of unilateral coercive measures. And more or less, as far as I see, not all countries intend to develop one, because if it will be clear what is illegal, so we can insist that what we're doing is not the unilateral coercive measures, so it shall be legal. As a result, one of the points what the special procedures can do is to write concerns about the problems, to speak about it at the academic level, at the NGOs, governmental and other level, to bring attention. It's very pity today that the world community is split as concerns the problem of application of unilateral sanctions. And we came to the point, unfortunately, that sanctioning and sanction states do not talk to each other. And that's a huge problem. You can't find consensus if you do not talk to each other. The same concerns academic society. Academics in sanctioning states are communicating to each other. And the same happens when we speak about academics in the sanctioned states as well. First of all, it's necessary, the purpose of the special procedures, and it's my purpose over here, to deliver the knowledge, what's happening and how much unilateral sanctions are affecting human rights. For example, the reports which I will deliver this Friday at the UN General Assembly will focus on the negative humanitarian impact of unilateral sanctions in the course of pandemic. And I'm very grateful for all states, for all NGOs, which provided this information because it's really unique. It provided me the possibility to start contacts with humanitarian NGOs, because in general, it has happened that they believed that no one knows about the problem they face in the field when trying to deliver humanitarian aid to targeted countries. Because if you look at the legislation, it usually said, wow, we provide a very nice humanitarian exceptions, but no one looks that the problem is very complicated, very expensive, very lengthy, and quite often it's impossible to get a license for delivering humanitarian aid. So the second point, what can be done by the special rapporteur, is to establish several different networks. The network of civil society, like cooperation with humanitarian NGOs, with academic institutions, is very necessary over here. We have just discussed the call for inputs, which have been forwarded by me for the report to the UN General Assembly. But in general, I'm planning to forward the next call for inputs for preparation of the reports for the next year. And the next call for inputs will focus on what unilateral coercive measures are. We need finally to decide what is legal and what is illegal. We need to do a definition and to provide legal qualification of facts, what are happening all around. And the second part of questions will be devoted to the question, who are targets of unilateral sanctions? Because we usually do not, people usually do not think how many people are affected by unilateral sanctions. And as a result, I'm very welcoming everyone's inputs on these points. It will be very much appreciated. I plan to place it on the web page somewhere in the mid-November, after the General Assembly is over and a little bit time passes on. So the second group of networking cooperation relates to the cooperation with the UN organs. Today, lots of UN organs are dealing with different groups of sanctions, but they do not communicate to each other. Moreover, quite often they speak about, for example, protection of human rights while countering international terrorism. And we know that sanctions quite often are imposed over there. And however, in practice, this organ doesn't cooperate to the UN organ which deals with the UN reform. They do not cooperate with me, they do not cooperate with the Commission dealing with economic sanctions. So one of the purposes which I plan to do is to make this network, let's say, functionable. And I believe in this case, it will demonstrate a real strength of the United Nations in being involved into this issue. So the second group of networks will be cooperation with regional actors, because as we see today, lots of regional actors are imposing unilateral sanctions as well. We can speak about the European Union sanctions or ECOWAS sanctions, which have been imposed recently against Mali, and some other ones. But again, as I have mentioned, the European Court of Justice is considering lots of cases, and it's necessary to take into account this expertise and to look trying for consensus over there. So as a result of the expert communication, as a result of collecting information and doing the research, the results of this research will be finally placed in the 2 reports, which are delivered by every special rapporteur, one for the Human Rights Council and the second for the UN General Assembly. That's basically the one have been done by me a month ago, and the next one for General Assembly will be done this Friday. Again, the special rapporteurs do country reports and country visits. For this year, for example, I'm planning to have a visit to Qatar, and in January, I'm supposed to have a visit to Venezuela if the coronavirus situation will allow to do it, because the Venezuela visit has already been moved later. And this situation provides the possibility to communicate to lots of people in the field and to see the problem in reality. Because quite often we live in one country and we do not know precisely what's happening somewhere and what human rights may be violated in one or another place. Well, another possible mechanism of these and another possible role of the special procedures and the role which I see for me is to bring attention of the governments on the possibility to use international institutionalized mechanism for prevention of imposition of unilateral sanctions. At the beginning of my speech, I mentioned that we started to forget about the principle of peaceful settlement of international disputes. There are lots of international institutions which can be used for this purpose. And for example, on these regards, I'm very much welcoming the efforts of Qatar, which has been sanctioned by 4 other states, not to start imposing sanctions on them in response, but turning to international competent bodies, including the International Court of Justice, the Dispute Settlement Body of the WTO, Universal Postal Union, and Committee on Liquidation of All Forms of Discrimination. That's the correct step, which shall be done in accordance with international law. As for the special procedures, it's also possible to bring attention of a specific government to the facts of violation of international law by introduction of new acts of legislation. So the particular example is the Global Magnitsky Act or some executive orders or Caesar Act. That's basically the problems I'm involved now, as well as the executive order which imposed sanctions over ICC judges and other ICC officials. Any sort of this activity can be taken either upon the request of a state which believes that it has been targeted by sanctions or upon individual complaint. So that's also a valid mechanism. And upon my opinion, using the mechanism of individual complaints is very important, because when we speak about sanctions, we usually speak about it about something amorphous. It's something what exists somewhere and we do not see a specific person affected by these sanctions. But if a person says, yes, my rights are violated by introduction of these unilateral sanctions or by introduction of this legislative act, the situation stops to be amorphous, it stops to be some sort of abstract. It becomes precise, and we speak about this specific person, specific rights, specific mechanism for the protection. So if a person believes that his or her rights have been violated by introduction of sanctions, they can request for unilateral complaint proceedings, And basically, well, even in my not such a long practice since the end of March, there have already been cases when I assessed the situation and forwarded a communication to the state concerned. However, I may say that unfortunately, as for now, I received no reply for any communication which was sent to the United States, even despite the fact that in some cases, it wasn't my individual communication. It was a communication, for example, when we speak the communication on ICC judges and officials. There were, I believe, 8 special rapporteurs which sent communication altogether, but we didn't receive any response. So that's basically a clear demonstration that there is no willingness to cooperate. But we need to start doing something, and to only by promoting the rule of law and the need to stick to the rule of law, there is any chance to get the problem settled. I will stop here, and if there are any questions, we would be happy to answer them.
Thank you very much, Professor Duhan. I hope that everyone has enjoyed the presentation till now. I personally learned a lot from your presentation. I see that there is one question from Mr. Muhammad Moin Watankha, and it says, generally sanctions are threats to the security of governments in various situations. And the purpose of sanctions is to force a country to do or not to do something. Unfortunately, the outbreak of the pandemic over the past 8 months has created difficult conditions for countries. My question is how important the role of this special procedure will be in such an awkward situation, and what is the main task of international organizations such as United Nations in this procedure?
Well, this question is definitely complicated. I responded to it, I tried to respond to it basically in my report to the General Assembly, and I hope very much that the state will be interested in this discussion, as well as NGOs will be interested in this discussion. Then I will probably speak in general when it comes to the United Nations organizations. One of the huge steps in this area was the fact that not only me, that's basically my task as an expert, but also the UN High Commission on Human Rights, as well as the UN Secretary General, has stated that saving lives shall be our priority. And moreover, they have also called for all states to lift or at least suspend application of unilateral sanctions in the course of the pandemic. Moreover, they have repeatedly called for the need to act in solidarity and cooperation in order to resist the pandemic. As far as I remember, in one of the reports prepared by the UN Secretary General, the UN Secretary General said that the World Health System is as strong as the weakest part of it is strong. Unfortunately, I need to say that it made some effect. Some of the effects, not a huge one, but still, some of the effects were that, for example, the European Union has eased a little bit the mechanism for granting humanitarian aid licenses. So the targeted countries complained that it didn't much good, but still it was an attempt to ease the process a little bit. From my perspective, I still criticize a lot the mechanism which exists, because upon my opinion, we should, if we speak about humanitarian aid, the organization which seeks to deliver humanitarian aid shall not prove that it will act bona fide. It shall be just granted upon request. And if something was done wrongly, for example, the organization used this money for supporting or financing terrorist activity, that will be the obligation of sanctioning countries to prove that there was a fact of violation. That's why the existing procedure is very bad from my perspective. Well, unfortunately, sanctions have not been listed, and when we speak, for example, about the United States, then they have been increased a lot. The most ridiculous point, upon my opinion, is application of the UN sanctions toward the research laboratories which develop antivirus vaccination, what took place as concerns Russian Federation laboratories and as well as Cuba system, when because the US insist that Cuba medical system is acting maliciously and they are not seeking to develop a vaccine in reality. Upon my opinion, I'm not an economist, I'm just a lawyer, but upon my opinion, the purpose of this sanctioning was to guarantee that the US will be a monopolist in development of the vaccination. So the purposes are purely economic. Well, as I have said, there is no such a great result as for now. However, it's already good that countries started to speak about the problem. And I believe that's also good, for example, that the European Union realized that quite a lot of the United States sanctions are violating fundamental human rights. Like when we speak about the ICC, there was a statement of the European Union official. The same concern the Nord Stream 2 sanction, the same concerns problems when the European Union countries were sought to be involved in tax payment system with Iran, and the same concern the recent Iranian system, sanctions against Iran and Cuba in the course of vaccination as well as concerns banks. So upon my opinion, we are now at the very first step. We are realizing that the problem exists and we start to raise awareness of the existence of this problem. Probably the next very important step is that humanitarian organizations all around the world realized basically that they are also targeted very much by application of unilateral sanctions. So pandemic made light of people to be so much affected because of unilateral sanctions that now it started to be obvious not only for those who are targeted, but also for everyone who is communicating with these people and with these states. So unfortunately, we are now only on the first step, but hopefully we'll be able to move further.
Thank you very much. I don't see any other questions from the participants, but I personally have a couple of questions which I wish to ask now. My first question is that when we are talking about the human rights negative effects of UCMs, are we only talking of extraterritorial UCMs or UCMs with extraterritorial effects, or even the primary sanctions of United States may be considered as having negative human rights effects?
Well, that's basically a good question because the answer is very simple. In general, I'm talking about the negative humanitarian effect of all types of sanctions, both primary and secondary. The difference between these types of sanctions concerns only the types of subjects which are affected by these sanctions, as well as different types of consequences. But in general, for example, when we speak about application of economic or sectoral sanctions, which are in general primarily, they affect a huge number of human rights, starting from economic rights, starting to social rights, right to education, prohibition of discrimination, rights of children, women, any other vulnerable categories of population. It's absolutely obvious if the economy of state is in crisis, rights of all people will be affected. Rights of all people who became employless, unemployed because of the application of sanctions against primary sanctions against a certain enterprise will definitely be violated because they all have their families, they also need to eat something. They need to guarantee that their normal living. The same concern the violation of the right to adequate housing, the right to the health, and in some cases, the right to life. The problem, so it's naturally not the same if, let's say, one person shoots another person, when we can conclude about the direct link between the action and the result. In this case, it will be much more non-selective, but still under certain conditions we may speak about the situations of people losing rights. And I will cite here the example which doesn't relate to the unilateral sanctions, but relates to the report which was done in, I believe, 2000, by a number of NGOs under the auspices of the Human Rights Council as concerned the humanitarian impact of the UN Security Council comprehensive sanctions against Iraq. And in accordance with this report, even the UN Security Council legal sanctions resulted in the increase of deaths among children beyond 5, 0 up to 5, plus 500,000 within 10 years. So 500,000 young children, 0 up to 5, died because application of absolutely legal sanctions of the UN Security Council. That's why, for example, when we speak about the countermeasures, we need to speak not about the possibility, is it allowed to apply countermeasures or is it not allowed? If we look at the draft articles on responsibility of states for international wrongful acts, it clearly said that the countermeasures shall first be proportionate, and secondly, it shall not constitute either reprisals or violation of fundamental human rights. That's why theoretically certain rights can be limited, but it shall in no way result in the violation of the right to life or any other fundamental human rights.
Thank you very much. My next question is that what about the claim by the sanctioning state that the unilateral coercive measures are necessary to protect the national security, which implies that the human rights of the sanctioning state people. So if these two human rights are in conflict, which one should be prioritized, or is the sanctioning state exempted from imposing unilateral coercive measures?
I will come here again to the point that I see it as a huge problem that we still do not have any definition of unilateral coercive measures. Both UN Human Rights Council and the UN General Assembly said that UCM are illegal. But it's no use to call them illegal if we do not know what is illegal. Everyone interprets it in the way which is convenient for them. When we speak about applying measures aimed to protect security of the sanctioned state, here again, it's necessary to follow the rule of law. Any countermeasures are allowed only in response to the violation of international law by another state, or in the situation when collective human rights or erga omnes obligations in understanding of the International Court of Justice are violated, and only when they are proportionate, when they do not violate fundamental human rights. There is no need to choose whose rights will be violated. Rights of others, our citizens, and rights of the citizens of any other country. There is a need to observe the rule of law. And that's why I believe it's so important to fix, and I hope it will be done in the next report, what measures can be qualified as countermeasures and what measures can't be qualified as such. And as a result, in this case, we will know if we behave in accordance with the rule of law, we definitely do not do any unilateral coercive measures. So if I come back to the exact wording of your question, no, you can't apply UCM in any case because UCM is something what is illegal. But you can apply countermeasures in order to protect the security of your citizens as long as these countermeasures are within the standards of international law.
Thank you very much. I see we've received another question from Mohsen, And he asks that many aid organizations are afraid of providing humanitarian aid to areas which are under the control of sanctioned governments or non-state entities, because it may amount to material support. Has been any effort to create legal safeguards against such trend in sanctioning?
Indeed, this is a very practical question, which became much more practical in the course of COVID, as far as the amount of humanitarian aid has increased during this period. Well, some steps have already been taken. So one of the very first steps which I tried to do, I elaborated the guidances for state, how they are supposed to behave in the course of COVID-19, in order to guarantee, to safeguard the human rights of people in the targeted states as well as targeted states. Well, upon this, the European Union has issued guidelines how to get humanitarian exceptions licenses. And that, I need to say, probably didn't help a lot, but that's a good step forwards. Because usually the mechanisms are very non-transparent. The humanitarian organization, for example, in the United States, need to pay a lot in order to get the humanitarian exception license to know how they can deliver humanitarian aid and not to be charged afterwards. So the European Union did a step forwards to explain the process. That's already good. Transparency is very important to guarantee human rights. However, it didn't help a lot because the same guidance which was issued by the European Commission said, for example, that please be very careful. For example, if you're delivering humanitarian aid to Syria, you need to get 2 licenses, because the first one for buying and delivering humanitarian aid to Syria, and second one for buying the gasoline for your car, with which you will deliver humanitarian aid within Syria, because there are sanctions as concern the oil industry of Syria, and if you buy gasoline in Syria, you may fall under secondary sanctions. So on this case, the only good point is that it's explained. So the attempts are made to explain how problematic it may be. From the other point, as I have already mentioned, the humanitarian organizations are really afraid to fall under secondary sanctions. And as a result, they started to cooperate. So first of all, they started to cooperate among themselves. And secondly, they started to cooperate actively with the mandate. For example, the next week, I'm supposed to have an expert meeting with humanitarian NGO to discuss the problems they face in delivering humanitarian aid and doing other type of humanitarian activity, upon which I hope to make recommendations and new guidelines for states, which hopefully will help to make the functioning of humanitarian aid easier. That will result that more humanitarian aid will be delivered and people will be helped as a result. But we also need to take into account that the problem of humanitarian aid is only, let's say, the first step of the problem. It's definitely necessary to assist people who have no means of subsistence. But in general, the main idea is to achieve the lifting of sanctions, because humanitarian aid is the means of survival today. The longer economy of states can function normally, the more society becomes dependent on humanitarian aid. And as a result, it undermines the ability of states to protect its own government. So the clear example is the Caesar Act as concerned the sanctioning involvement into any reconstruction activity in Syria. So in this case, state can't protect its nationals, can't build the houses, can't do reconstruction, people do not get jobs. So therefore, it's good that humanitarian aid is delivered. It helps to save lives of people. which are suffering because of absence of any means of subsistence. But parallel, it's necessary to work on the way of lifting, unilateral sanctions. Hopefully, we'll be able to find any proposals and solutions when cooperating with humanitarian organizations.
Thank you very much, Professor Duhan. I don't see any other questions from the participants. So if you do not have more comments.
As far as I see, one came.
One came? Oh
yeah, I believe.
Yeah, that's right. It's one from Melika. She asks that due to the problems that we have in Iran, what can we do for people to get less damage? It's a very, very general question.
Well, I have a feeling that I got confused with this question. Let's say I'm just the special rapporteur. Let's see, again, the only way I see now is to try to establish cooperation and consolidation among the international society. To build, probably if some cooperation networks are broken, to build a new one. As far as I see, one of the possible mechanisms is that countries started to grew up at least the basic food and basic humanitarian essence stuff in the country. It's probably prevents development of globalization, but it helps people survival, and some countries have no other way to do. The third way is to seek to establish cooperation with sanctioning states too. I realize, I'm quite aware that quite often targeted countries, they really feel being very, very, very hot. And they quite often even do not want to communicate to sanctioning countries. But the problem could only be solved if the cooperation starts. It's necessary to find a solution. If we do not do it, the world community will stay split and we won't solve the problem.
Thank you very much, Professor Duhan. I think that there is no more questions, and let's make sure. There's no more questions, I think. Thank you very much, Professor Duhan, for answering the questions and having a very great presentation. It was a great pleasure to have you with us, and I hope we can organize more events on the subject with your presence in future. So if you do not have more comments, this concludes the webinar. I thank you and all participants for attending, and we hope all participants have enjoyed this presentation.
Thank you very much. It was a pleasure for me too.
Thank you very much, Professor, and have a good night.
You too.